Ready to strengthen your reading comprehension? Take a listen.
Okay, let's dive right into this. Imagine for a second losing your home through foreclosure, right? And then you're actually evicted before a judge ever even hears your argument about why you legally still own the property. No way, right? It sounds like some crazy procedural glitch, but actually, this is a very real, incredibly high-stakes tension happening right now in the state of Georgia when it comes to post-foreclosure evictions. So today's explainer is all about this massive clash between judicial efficiency, just getting things done quickly, and substantive property rights. It's a completely fascinating look at how the law actually operates on the ground versus how it's written in the books.
We're going to break down this incredibly complex legal tension step by step. We'll start with the post-foreclosure problem, then we'll compare the theory to the practice. After that, we're going to deconstruct the statute itself, look at the due process tension it creates, and finally, wrap up with the winning legal framing you can use to challenge it. Let's get started.
Section 1. The post-foreclosure problem, the fiction of the holdover.
Right at the center of this whole dispute is this really fascinating legal fiction found in Georgia statute OCGA section 447050. Look, when someone's house is foreclosed upon, they don't always just pack up and leave immediately, right? Especially if they firmly believe the foreclosure was wrongful. But the legal system, it needs a way to categorize them to keep the gears turning. So this specific statute provides a limited, fast-track procedure to remove what it calls a tenant at sufferance. Here's the wild part. By operation of law, the very second the foreclosure happens, the former homeowner is instantly reclassified. You are no longer an owner disputing a bank's claim. Legally, you're treated as a mere tenant who has overstayed their welcome. It's crazy, but this simple reclassification is literally the magic key that unlocks a hyper-fast eviction process.
Moving on to Section 2, Theory versus Practice, the dual reality.
And this brilliantly illustrates a huge problem, because how the courts describe this process and how it actually feels to the person losing their house, well, those are two entirely different things. In theory, under binding Georgia doctrine, courts view this whole thing as a completely neutral jurisdictional division of labor. The court handling the eviction gets a fast-track question: who has the right to possess the property today? Any of the messy questions about who actually holds the true title or whether the foreclosure was even legal, well, those are pushed to a completely separate lawsuit. The court basically says, hey, we aren't crushing your rights, we're just handling possession now, and you can argue title later. But in practice, this framework heavily prioritizes speed and rapid eviction. It functionally delays any meaningful property rights adjudication until after the family has already been kicked out onto the street.
So out in the real world, this builds a really stark fast versus slow structural timeline. Let's walk through it. Step 1, a non-judicial foreclosure happens. Step 2, the occupant is immediately reclassified as a tenant at sufferance. Step 3, a rapid eviction proceeds, and get this, defenses about the foreclosure's actual validity are completely excluded from the courtroom. Banned. And finally, Step 4, the dispossessed owner is forced to file a completely separate, much slower action to try and win back their rights. You can probably see the inherent flaw right here. The timing forces a substantive loss of property before anyone ever gets a real day in court to argue ownership.
Which brings us to Section 3, Deconstructing the Statute, Anatomy of an Argument. Okay, to actually challenge this, we have to kind of act as legal mechanics. We need to break open the statute using 3 core principles of legal interpretation to see exactly where it misfires. Our first tool is a Latin phrase, in pari materia. Now, don't let the Latin scare you. This simply means that statutes dealing with the exact same subject matter must be read together as one cohesive whole. It's like a giant puzzle. You can't just read the eviction statute in a vacuum. You absolutely have to read it alongside the state's foreclosure laws and property title laws to actually understand the complete legal landscape.
When we actually do that, reading the statutes together reveals a very intentional design by the legislature. They created a summary possession mechanism, so that's the fast track, and a separate, slower title adjudication pathway. This is an intentional dual-track system. Make sense? The fast track was clearly meant for landlords getting rid of actual renters, while the slow track was meant for complicated ownership disputes.
All right, now for our second set of interpretive tools, nulcitur associis and aegistum generis. Again, fancy Latin, but these principles just mean that words in a statute are defined by the company they keep, and general terms have to belong to the exact same specific class as the words around them. And if you look closely, the eviction statute constantly uses words like landlord, tenant, and holding over.
So here's the absolutely crucial point. Under these principles, a tenant at sufferance should logically refer to a residual category of consensual possession that has just lapsed. Like a renter whose 1-year lease expired, but they just haven't moved out yet. A foreclosed homeowner aggressively disputing a bank's claim is absolutely not of the same genus or class as a holdover tenant under a consensual lease. Not even close. Using the statute to magically turn a dispossessed owner into a renter is a massive, massive stretch of the legal text.
Which leads us directly to our final Latin tool for today, expressio unios est exclusio alterius. Translation: the expression of one thing is the exclusion of the other. Basically, if a law specifically lists certain things it does, it implicitly excludes the things it leaves out.
Notice how the statute expressly provides a summary remedy for landlords to recover possession from tenants, but it completely leaves out any mechanism to adjudicate disputed title. It completely omits any authority to convert a contested ownership interest into a tenancy just for the sake of a quick removal. Because title adjudication is omitted here, using this eviction statute to effectively bypass title litigation is functionally what we call ultra-virus, which is just a legal term meaning it operates way beyond its actual legal power.
Section 4. The due process tension. The core observation.
Now, this whole statutory breakdown reveals a massive constitutional pressure point. Listen, if you are ever arguing this in court or analyzing the policy, how you frame this tension is quite literally the difference between winning and losing. A lot of folks get this wrong by using a flawed framing. They argue that the court openly values efficiency over constitutional rights. I'll tell you right now, if you stand in front of a judge and say, "You just care about speed more than my rights," you will lose. The judge will just point to the doctrine and say, "Nope, we are just dividing the labor." Instead, the winning framing argues that the sequence of these procedures functionally prioritizes procedural efficiency over substantive due process. See the difference? You aren't arguing that the court actually wants to crush rights. You are arguing that the way the system is ordered mathematically results in a denial of due process.
It really all comes down to a devastating procedural inversion. Think about it. Possession is removed first, and rights are adjudicated later. Losing your house before you even have the opportunity to prove you legally own it? Well, that is the ultimate due process sequencing problem.
Finally, Section 5. The winning legal framing. Court-safe articulation.
So how do we put all of this together into a really targeted argument? Well, if you're drafting a brief, a motion, or just analyzing this legally, you need exact, highly calibrated language. Here is the court-safe articulation straight from our source analysis. Quote, "The occupant's loss of possession precedes any meaningful adjudication of underlying property rights, raising a substantial question whether the procedure, as applied, functionally elevates administrative efficiency over the protection of substantive property interests." End quote. I really emphasize that wording because that is how you make a judge stop and listen. You are pointing out a structural flaw, a procedural sequence that accidentally crushes a constitutional right. Now, a quick warning on the limits of this approach. Courts rely heavily on settled black-letter procedure. They view foreclosures as presumptively valid until proven otherwise. So whatever you do, do not argue against the existence of the dispossessory system itself. That's a losing battle. Instead, definitely do attack the legal fiction that a homeowner is a mere tenant, and absolutely do attack the sequencing of the remedies. The sheer fact that the eviction happens long before the title dispute can even be heard. We've unpacked the fiction of the holdover, we've deconstructed the statutes, and hopefully armed you with a court-safe framing of the due process tension. So I'm going to leave you with this final, provocative thought directly from the source material. Armed with this toolkit, are you ready to climb the appellate ladder to ensure actual justice is administered, rather than just letting the mere marketability of titles supersede constitutionally protected property rights? It's a steep climb, for sure, but as we've seen today, the legal roadmap is right there. Keep questioning, keep analyzing, and I'll catch you on the next explainer.
Crossing guard, I was like, what you doing? You cannot stop me. Pretty God.